Thank you for organizing this conference, for the invitation to be a part of it. Thank you, Lee, for your book, for your amazing work. I feel so honored to be a part of this conversation with amazing co-panelists whose work I respect and admire, and really look forward to this conversation. And thank you to all of you for being here on what, for someone coming from a very gloomy and chilly New York, is like a gorgeous day. So thank you. Okay, so first I want to say a few words about the book overall, just a few, because I think we'll talk about it later. But I just want to really say kudos, Lee, for pulling together so many, both a summary and a critique of so many of the current and critical legal and policy approaches to gender violence that we are grappling with and have been grappling with for the last few decades. It's an impressive compilation of both statistics and anecdotes. So it's a really great resource. I already have recommended it to a few students and others. And the combination of data and narrative and stories really makes a persuasive case for change. So it's a great illustration, I think, about how to pull together different forms of argument in service of policy-based change. And to that, we owe you a great deal of gratitude. So there's a lot I can say, and I look forward to the conversation, but my remarks are going to focus on human rights. And the human rights chapter in particular powerfully reviews the international and regional treaties and other sources of international human rights law that require states to respond to gender violence. It reviews the case law, it reviews major issues. I'll say a bit about some of those. But my remarks are really going to focus on two of the issues that Lee raises in her chapter. And I think what I'm going to do is expand on some of the themes and some of the issues and concerns that you raise. So one is the impact of the gendered framing, what I tend to call the gender-specific frame of many international human rights instruments. So what do you think of when you think of international human rights law and what I'll call gender violence? Violence against women, and I think of that as a gender-specific frame, and I'll talk a bit as picking up on some of the themes that Lee establishes about some of the benefits but some of the risks of that framing. And then I'll also talk about the power and the limits of the due diligence principles, as Lee talked about earlier. And just to say a word about how I come to this work, I actually started working on issues of gender violence. I don't want to date myself, but I'll just say that I started working as a volunteer in a community-based program in Brooklyn, New York, that established home-based shelters. It was before we had a shelter system, really. Home-based shelters for women who were looking for safety. And then and I was a community organizer, so I really appreciate your approaches and look forward to talking about that more. After I became a lawyer, most of my work, pretty much all of my work has focused on the civil side. So I very much appreciate the question about civil remedies and would be happy to talk about civil and civil rights remedies in particular, also with pros and cons, value and limitations. And that's part of what has led me to do some work around human rights principles. So I guess the overview of what I want to say is I really appreciate the framing of human rights and the potential that human rights holds as a way to shift our perception of issues of gender violence. But I also want to say that the human rights frame alone in and of itself is not a panacea. So as with everything, and I think this might be a thread with perhaps all of our comments today, any particular strategy is really only as good as we make it. So, and I'll give some specifics about my thoughts about the human rights frame in particular. So first, with respect to the gender-specific framing. So one of the most common, and Lee, I think you correctly point this out, one of the most common tools that we often think about when we think about human rights and intimate partner violence or gender violence, and I also will use those terms somewhat interchangeably, is Cedaw. How many of you have heard of Cedaw? Okay, so Cedaw, for those of you who haven't heard of it, is the Convention on the Elimination of All Forms of Discrimination Against Women. Many, many countries have signed on to it. The United States is one of a few that have not. It addresses discrimination generally. The terms of the treaty itself, as Lee discusses, don't talk about violence against women or gender violence. But in what's called a general recommendation, the Cedaw Committee issued an entire list of describing how gender violence is a form of discrimination against women and what states' responsibilities are to address it. So not all human rights instruments that have been used to address gender violence are framed in that gender-specific way. Some talk about prohibitions on things like discrimination and prohibit discrimination on a number of grounds, including sex discrimination. So one of the things I just want to say a few words about is the contrast between that gender-specific, in other words, violence against women frame, and what I would call a gender-neutral frame that nevertheless recognizes that domestic violence, intimate partner violence, sexual assault, anti-gay attacks, other forms of homophobic violence can be a form of sex or gender-based discrimination. So I'll say first, generally, all of these instruments go further than our current US-based human rights law because they connect gender violence and discrimination. And what do I mean by that? They connect gender violence with historic biases, with historic stereotypes, with historic views that men are entitled to, and I'm just generalizing, but men are entitled to abuse women, that sexual assault is acceptable. The kind of stereotypes about survivors that we all hear all too often. And whether the framing is violence against women, gender specific, or more gender neutral, recognizing gender violence as a form of sex discrimination, international human rights law has actually gone some distance in recognizing that gender violence itself and that states' responses to it are a form, an impermissible form of sex discrimination through which states violate their obligations under international law. And this is really powerful. So I've spent some time looking at decisions both that have been issued by the Cedaw committee, that's the committee that's entrusted with adjudicating complaints brought under Cedaw, that international treaty, and decisions by the European Court of Human Rights, which is a court in Europe that is charged with adjudicating complaints brought under the European Convention on Human Rights, which is one of these conventions that prohibits, among other things, sex discrimination. And there is now a good body of case law that recognizes that gender violence and states' responses to it constitutes a form of discrimination. And in those decisions, there's really powerful discussion about the kinds of policies and practices that I think we all know that we feel are discriminatory in some way, and we struggle under US law to name it. There are international human rights decisions that recognize, for example, then that when a lower court dismisses in this case, a woman's complaint of violence, finding that she provoked her abuser, that was a form of sex discrimination. Or cases finding that law enforcement's failure to investigate a complaint or unreasonable delays in responding to requests even for civil injunctions, or their general passivity. There's a lot of discussion about authorities' general passivity, dismissive attitudes, or just their attitudes reflect gender bias. And we have a really hard time because of a variety of doctrinal hurdles getting courts to recognize that kind of bias under our US system. Importantly, and Lee discusses this, I think, very powerfully, international human rights law provides a lens for talking about intersectionality. So in 2015 and 2017 in particular, the Cedaw Committee, which is the committee charged with enforcing and implementing that convention, issued some new general recommendations that do a number of things, one of which is specifically recognizing intersectionality. How many people are familiar with the concept of intersectionality, I hope? So the ways that various forms of discrimination, bias, subordination intersect. And the committee in its document recognized that discrimination against women, so it uses that gender-specific frame, is inextricably linked to other factors that affect their lives. Long list of factors including ethnicity, race, indigenous or minority status, color, socioeconomic status and or caste, language, religion, belief, being lesbian, bisexual, transgender, or intersex. So opening up a broad array of the different ways that we know that people's status as members of different marginalized groups combine to increase the harms of gender violence and the harms of the ways that systems respond to them. And there are a number of decisions, including the two that Lee talks about, the Linehan decision from the US, the Gonzalez decision out of Mexico. There are a few decisions out of Europe that also recognize, for example, that a complainant's vulnerability as an illiterate migrant woman compounded her vulnerability. Case out of Canada that recognized that a woman's dual statuses as an Aboriginal and a DV, domestic violence survivor, also increased her vulnerability. So I think this gives us reason for using and looking to international human rights systems. One additional part, and Deborah, I think this will intersect, so to speak, with your comments, is that in the Cedaw most recent general recommendation, they recognized the role of structural inequalities, the role of the reduction in public spending, austerity economics, extraterritorial corporate behavior, also as impediments to gender violence. So I think really important for us to note the international recognition of the way that structural factors increase vulnerability to gender violence, for us to think about how to make use of that as advocates. So, power of the international framing. At the same time, there are some problems. So, in particular, I've written about being critical of this gender-specific frame, and I just will say a few things about that. So, one is that it's inherently protectionist in some ways that I would call paternalist, maybe maternalist, I don't know, but I'll use the paternalist frame. So, decision after decision follows the international human rights framework requiring states to protect victims of human rights abuses. And case after case talks about states' failure to protect women, which leads me to just cringe every time I read that. How do we square that with what we know is the reality of women's lives, survivors' lives, who are really strong? And protection is just a word that leaves me a little uncomfortable. Similarly, decision after decision recognize that gender violence in states' response discriminate against women, so that's great, but discriminate against women as a woman, leaving me to wonder, like, what does that mean? Women are really different, and how much does that both reinforce a gender binary and also reinforce stereotypes about who women are and what our experiences are? Then there's also the issue that Lee talks about well, which I think is the limitation of the gender lens. So just on its face, you look at the Cedaw, violence against women, that frame leaves out men, gay men, trans men. Where do they fit in the picture? And Lee, I know that you posit that at least some male victims of domestic violence might be covered under some of the international human rights treaties, and I certainly hope you're right. But I worry that with the emphasis on violence against women, that it's a hard road to hoe. So we see an increasing recognition about violence against lesbians, maybe violence against trans women, but what about men? And I will just raise as a point of comparison, under the European Convention on Human Rights, which is one of these neutrally framed treaties that prohibits discrimination based on sex as well as a number of other grounds, there have been a number of decisions that have found that states violated their obligations and that they specifically their obligations prohibiting sex discrimination in their responses, say, to men who were attacked after coming back from an annual gay pride march in Bucharest, or another case in which a trans woman suffered physical and psychological abuse by a police officer, or a case in which a Turkish national who was seeking to migrate to Greece but was raped by a Greek Coast Guard official because of his sexual orientation, found that those violated international obligations, and just posit whether or not that neutral framing opens us up more both to address sexual assault as well as domestic violence, to build off of Candace's point, and to look across identities more broadly at the impact of gender. The second thing I want to talk about is the due diligence framework, as Lee talked about. So powerful for many reasons, embraced for many reasons. It advances the international human rights authorities' edict that states have responsibilities both to, as Lee said, prevent, protect, provide redress, as well as to prosecute and punish. What's troubling to me, given the limitations of time, what's troubling to me is the way that case after case addresses the challenge of looking at complaints that states fail to respond to requests for help by saying things like, a perpetrator's rights cannot supersede a victim's human rights to life and to physical and mental integrity. So at the same time that international human rights law does provide a broad range and an opening to talk about equality and dignity in so many ways, we also see court after court, Cedaw committee decision after Cedaw committee decision, really elevating the role of criminal justice interventions over a survivor's autonomy interests. And Lee, I think you make this point so powerfully, calling for us to think about in our advocacy, how might we more explicitly call for an incorporation of a recognition of autonomy rights? A number of years ago, I looked at states' reports. Under international human rights law, states have to report on what they're doing to comply with their obligations, and Cedaw is one of those treaties that requires state reports. And I took a look at what states had done, looked at all of the reports that they had submitted. I was curious what they were doing to advance anti-discrimination obligations. What did I find when I looked at those reports? By and large, the overwhelming response by states to their Cedaw obligations was criminal justice interventions. So that was, and you see that in the international human rights law decisions as well. They'll find that a state violated their anti-discrimination obligations, but what's the remedy that the court imposes? Fix your criminal justice system. So that may be one thing that's really important, but it's certainly not the only thing that a state should be doing in order to comply with its anti-discrimination obligations. So I think overall, and I think my time is probably just about up, as we think about international human rights, it's a really powerful tool. I would agree, Lee, with your recommendation that we adopt and ratify Cedaw, other international human rights instruments, but those instruments are only going to be as good as we make them through our advocacy. In a sense, law and policymakers have been trained, I think, by us as advocates to use the criminal justice system as the go-to response. I think some really because they don't know better, and I'm thinking about a meeting I had earlier this week with a New York City Council member who was trying to brainstorm about different legislative ideas, somebody who doesn't come out of the anti-violence movement. And she had proposed legislation. It was a big part of it was about police reports and police this and police that. And I started asking her, why? What are your goals? What do you want to see? And I started talking to her about economics and the role of economics in domestic violence. She was focusing on domestic violence. And I felt like I saw a light bulb go off in her head. She literally said to me, oh, this is what I'm hearing from other communities, that they want economic remedies, that they don't want criminal justice remedies. And so that, to me, I think, highlights the importance of this conversation here and for all of us to think creatively, idealistically, boldly about how we could build a blueprint for a more transformative and progressive future. Thank you.